the academy, and now the academy is fully established, and I think we are establishing here the fourth pillar of the environmental law program. So if I could say in terms of the future being for the next 4 years, and I was challenged by the present chair, Sheila Bed, is that our hope, with the help of all of you, PACE Law School, ELI, and the other partners, that at the end of 4 years we can have the Judicial Institute recognized by IUCN, or in the process of recognition as the fourth pillar of our environmental law program. And in my view, that will be the moment when we say, and I should not say this because the person that used the phrase did it in a very complicated context, but I'll say in French, which probably sounds better, mission accomplie. The fellow that said that in English is not exactly one with whom I share a lot. But in French, it sounds much better, and it doesn't sound like I'm repeating that phrase, which is, once used in that context, we are almost completely forbidden of using it again. Let me now say a few things about judges and the environment. And of course, the last speaker is one that would probably, I hope you have brought your anti-fire suits, clothes, because Tonio Posa, I'm sure, would put this room on fire. But without doing this, but perhaps preparing us for what Tony will say, and building on what Meredith, Nick, and Jay have already said, let me complement everything that they said from my perspective. Why is that now is the right time to talk about judges and the environment? You might say, well, the right time has been, or should have been, since day one of environmental law. So from 1969 in the US, the late 60s in Sweden, and in other parts of the world, that was the right moment to talk about judges and environment. We didn't. Why is that we didn't? We didn't because 4 things were missing. The first thing that was missing was good science that judges could rely upon. You might say, well, at that time we already had good science. Yes, we had good science, but it was good science that was in academy. It was not good science that was on television. It was not good science that was in books that judges had access to. So nowadays, judges don't need to look at scientific data that comes from nowhere, that they are afraid of citing because they might be quoting data that is not appropriate for a judge to do so. So nowadays, from the most prestigious science academies to governmental reports, United Nations reports, we have very good science in, on which judges can rely in deciding environmental cases. Well, second, and I lost my reading glasses.
Where are we?
Oh, excuse me. Second, we, at that time, when environmental law started, we didn't see environmental law as something different from traditional legal disciplines. We saw that as an evolution of traditional legal disciplines. And we were missing probably the most important of environmental law, which is its ethical foundation. It was not just changing property laws. It was not just changing the way we related in the legal framework with natural resources. We were fundamentally changing the ethical underpinnings of a particular legal discipline. And judges were not aware of that until very recently. In fact, most judges are not aware of that. And it's our duty to make sure that in addition to, and let me quote an article that I have just finished writing, in addition to the ethics of nature and the ethics in nature, we also have an ecological ethics of the judicial decision making. So this is profoundly transformative of the way judges operate and legal disciplines operate. So this is the second background change that allows us to be here today. Well, third, we judges, particularly judges in civil law countries, we cannot operate without good laws. And what do we have now? We have laws everywhere. Good laws, bad laws, everywhere, dealing with natural resources and the protection of the environment. We could call that a planet of laws. So this planet of laws foundation was not present in day one of environmental law. And fourth, this is probably the component that was really missing at that time, and it's missing in many parts of the world still, is that we cannot have judges performing in the environmental law context without what we could call an ecological or an environmental rule of law. Judges that are afraid of enforcing environmental laws will not be good judges. Judges that are afraid of being killed, of their family being in danger, will not produce good environmental decisions. Judges that are not afraid of being killed are perhaps independent, but are working in a system which does not guarantee public participation in the administrative proceedings, and also in access to justice, as Judge Meredith has just mentioned, will not perform well in protecting the environment. So those are the four, there are others, but the four components that were not in, can I say, in conjunction at that time, and nowadays they are present in most parts of the world. Let me finish with a couple of challenges, and I'm sure that Tony will have a whole list, a laundry list of challenges for judges. I would like to discuss just two of them, and they are really related to each other. We tend to see people saying, well, you know, environmental law is so complex, judges cannot really deal with issues of that complexity. Well, judges do with issues of complexity every day. Every single day. To me, there is nothing more complex than family law. And we do it every day. We take it for granted. We decide about love and hate in family affairs. Can you imagine something more complex than this? But indeed, there are issues that are very complex that we need to address in order to make sure that judges perform well. And we can do that both at the procedural level and at the substantive level. We can develop new principles as we are doing, for example, with the most recent addition to the laundry list of environmental law principles, the in dubio pro natura principle, which can be seen as a natural consequence of the precautionary principle, but it has also applications in civil procedure, not just at the substantive level, not just in an environment impact statement perspective, in a permitting process. The second and final challenge that I would like to discuss here, in fact, just to express a concern that I have, is the notion that in order to protect the environment, judges have to be specialized. We have been discussing this and taking for granted that there is only one direction for judges in order to protect the environment, is that we have to create green courts. And then we might ask, there's now research done on those specialized courts. Have they performed much, much better than ordinary courts? This is the first question. Second, we have not discussed the risks of creating environmental courts, and we have to do it. We cannot just transplant models from one system to the other, or from the rich to the poor, or from the poor to the rich. We have to discuss the whole picture. And I'm saying this because I'm a supporter of environmental courts, specialized courts, but I want to have a full debate on this. We cannot, I don't have the word in English, it's moralizado. We cannot be embarrassed. It's not the right translation, but yeah, it's close to it. We cannot be embarrassed, because it will be the environment that we will be embarrassed if we establish a whole new system of environmental courts and that system fails. And fails because of capture, corruption, and other things that are evil in our societies, and no specialized court will be different from... you can't build a paradise in a contaminated site. If the whole country is chaotic, if the whole judicial system is not independent, and I think Jay was too elegant with the words that he used, if the country is not prepared for having independent courts, the fact that we are creating environmental courts might be just greenwashing. Disheartened, that's what I meant.
Good translator.
Yeah, good translation, very elegant in fact. So, I say all this and I repeat, not because I'm against specialized courts. I have defended them in my country, but I want every single country to think thoroughly and critically about that. Take the example of India. It's the second time that India, a country that I admire the most, it's one of the most, if not, I mean, it's the largest democracy in the world. It's a country which has a spectacular independent judiciary, but the specialized court failed before. And are we asking the questions, the right questions now? Why did they fail? Are the new ones designed to fail as well? I'm sure they are not. They will not fail, and we can't take this risk. But my point here, in closing, is that we need to have a full discussion on this issue. Professor Nicholas Robinson has just attended a major judicial conference in Manaus, in which we had over 200 judges from all over the country, federal, state, High Court, State Supreme Court, Federal Court of Appeals, and the presiding justice from the only specialized chamber in a state Supreme Court in Brazil, and that's the largest state Supreme Court we have, it's in Sao Paulo, it spoke very much against specialized trial courts. And what's interesting here is that some of the judges were very critical of his speech. And then there was a debate whether we should publish his speech in the Brazilian Environmental Law Review, which is the leading environmental law review. And of course, that will be published because it's important that those voices are heard. Of course, there is a trend towards specialized courts, but we need to hear all voices, and especially the voice of those that are experienced judges, and they know what they're talking about, or at least they can make a good case for specializing a chamber in the Supreme Court, especially in a large Supreme Court like Sao Paulo, but not specializing individual judges all over the state, because that would probably not work well in the Brazilian context. So my commitment here, Madam Chair, Sheila Ed, is that in the next 4 years, with our partners, ELI, Hayes Law School, and all of you, we will do our best to make the Judicial Institute the fourth pillar of our commission, I'm sorry, the IUCN Environmental Law Program. And I'm told by ELI, by John Cruden, someone that arrives to ELI full of energy, that the whole institute will be dedicated to this enterprise. And if we are all together, I have no doubt that we will succeed. So thank you very much.
I have a question.
At the end?
Apparently,
well,
Tony,
no, Tony.
I can do it now.
No, but Tony is speaking.
Okay.
You're the chair. You have.
Yeah, that's right.
No, you go there and I will ask you. Okay, no, but okay, because we have a question for you regarding Latin America.
Okay.
One concern about the Latin American judiciary that keep arising is that what will happen, and the problem is how to set the correct direction regarding that. Some people are afraid that if you create specialized courts, they will not be, the very important cases will not be referred to them, because they will say, no, this is not an environmental issue, this is something regarding infrastructure, or regarding this, or regarding that. How will you prevent this? Because I know in the case of many countries, Mercosur countries, I'm not speaking about Brazil, but I know of Argentina, Uruguay, and Paraguay, they're afraid that this will happen, that you create like a silo which only birds or protected areas will go, but the very big issues, they will say, this is not really an environmental case.
There are many issues, as Justice Elijah will say, just arriving, but there are many issues in respect to specialized courts. For example, in the state of Amazonas, which is the size of probably California and Texas together. It's 1 million over 1 million square kilometers. It's a huge state. Where are you going to put this specialized judge? Can you afford to have one specialized judge in every single municipality where judges are placed? If you put a specialized judge in Manaus, how is the evidence going to be produced? How are you going to bring the witness of a major deforestation case that it takes a jet, a 2-hour flight in order to reach the other side of the state? And if you go by boat, which is most often the way you do it, it takes 15 days. So how are you going to do it? Are you going to take the judges there, or are you going to bring the witness? What about the technical expertise? How are you going to do it? So those are issues that we have to address. And there is another problem that I don't have the time here to address. When we talk about ecological integrity, and it's a term that Klaus Bosserman